Hello friends, are you looking for a best advocate for the High Court? So let me tell you, advocacy is not all about shouting. Advocacy is all about arguing with proper reasoning. Argument itself is giving proper reasoning in the most humble way. The professional relationship between an advocate and the judge is very, you can say, I cannot describe with an appropriate word. Like you can say it's very professional. At the same time it is I can say, yes, I can say like if you go to a temple, there is a god and there is a priest is an advocate and god is a judge, as simple as that. Without priest, if you go to a temple, there is nothing that you can do. You don't know anything. You don't know how to perform a prayer. You can just fold your hands and beg the god. That's it, what you can do. But you cannot talk to the language which the god knows. That is what the language which the judge knows is law. That's why a lawyer is very important. So if you have a right professional lawyer who can put all the arguments in a very decent and very appropriate and very pleasing manner before the judge without irritating the judges, because judges role is a very irritant role, because judges often get irritated. 99% of the time, every judge in the country is almost burdened with hundreds and thousands of lakhs of times of the work what he is normally supposed to perform, more than that. So that's why they often get irritated. They have to adjudicate at least 500 to 1000 matters a day. Every day there will be 500 for disposal, and they will keep on either postpone half of them, and 10 or 20% they will adjudicate straight away. So the 24 hours period for them will not be sufficient. They are also human beings. You must remember, there are a lot of advocates in the country who irritate judges. They will not be able to get orders. Only the advocates who please the judges in most appropriate way, and they argue less and argue very effectively with proper decorum, will only be able to get or fetch reliefs for their clients. That is very important. This is all about the art of advocacy. It's not that easy task for anybody to argue in the constitutional courts. Most of them, I have seen the advocates, either they shout at the judges, they fight with the judges, or they take the cases of the clients very personally and they start fighting with the judges because they are not listening to their facts. First of all, the constitutional courts are not fact finding courts. It is too immature for the High Court or Supreme Court to seize the matter, because once a matter has come for an appeal, then only they'll have all the facts of the matter. There are two types of things. One is facts in issue and relevant facts. These two things have to be proved only in the trial courts. Once these two things are established on paper, then only the High Court or a Supreme Court can take a call in an appropriate way. But beforehand, if you come to a High Court with a quashing case or any kind of writ petition or anything which has not touched the lower court, and you try to argue with the judge on facts and try to convince him, he will not get convinced, because the High Courts and Supreme Courts are there only for maintaining the rule of law. If there is no efficacious remedy in the rule of law, they are the creators of law. Based on the facts and circumstances, they will issue an order, because it's an equitable jurisdiction. They will issue an order which will itself become a law. For example, there are two warring parties, two neighbors. Let's say both of them have built illegal buildings, illegal construction. One person might get a stay order, one person might not get a stay order, and his house will be demolished. So the rule of law remains same for both the parties, but facts and circumstances might be different. Who is arguing? Which advocate has argued for whom? That is first thing. And what is the perspective of the judge, and what way he has presented the case, and what are the facts and circumstances which led the judge to give some kind of lenience and some kind of relief to the one person and not to other person. The judge might also be same, and the advocate might also be same. Let's say item number 30, a person has taken a stay order, and item number 31, the judge is not pleased. So he thought, one is enough for this advocate and I will dismiss it. That's it. The second will become a rule of law. It has to be demolished. So the High Courts and Supreme Court, whatever the orders they issue in the extraordinary jurisdiction, will become a law, because it is called equitable jurisdiction. So the art of, coming back to the point of art of advocacy, it is very important for an advocate or a counsel to behave well in the court of law before the judge. The only way is to make him, to please him, not to annoy him. Never annoy the judges. Otherwise, it will be very it will prove very, very costly for you. Recently, in the Honorable Supreme Court of India, I have seen a gentleman, one of the senior advocates, he has argued. His argument was fantastic, but his address to the Honorable Supreme Court was terrible. He was again and again saying, you must see this, you must see this, to the honorable bench. And he has said this, you. At least he has said 1,000 times in a half an hour to 45 minutes of argument. You can imagine what was the kind of reaction the judges were having. They did not say anything, but they were shocked he was a senior designate advocate. They were shocked to listen to such kind of undecorum argument, and they have raised an objection. But he said, you means not you means Supreme Court. I am referring to the Supreme Court of India. That's fine. That is very wrong what he has said, the way he has presented. And he lost the case straight away. It was dismissed, and the next time also he has not improved in the same way he has argued. Now his senior designate tag is under under again reconsideration. The Supreme Court has issued a notice to him, contempt notice to him, and they are likely to strip him off from that senior designate tag. So the art of arguing is very difficult. Even the most advocates in the Supreme Court of India also somersault in this case, because it's not that easy. Arguing is a very big art. One has to give lot of proper reasoning, logical reasoning, with the proper judgments and binding precedents of either High Court or Supreme Court, and rule of law, question of law, legal grounds, and facts and circumstances. What are the proved facts? What are could not be proved? What is the main thing is the evidence. What evidence you have that you are bringing it to the bench? That is of the utmost importance. If you have best evidence, then you can definitely convince the court, and you don't have to ask for the order. The court will straight away will give you, because in the kind of most of the judges in the High Court also, the learned single sitting judges and the senior judges in the division bench also, yes, division bench is as good as equal to the division bench of the Supreme Court. In the High Court judges also, they read the whole file before they come to the admission hearing. So in the Supreme Court also, there is a practice, all the judges, they'll read all the file thoroughly, and they'll come to the court well prepared, more than the counsel. So straight away they'll ask all very, very, very tough and tricky questions, which you might not be able to satisfy them or answer them within a minute or half minute. That's why you are not getting relief. So you must remember. But if your counsel or your advocate is begging and pleading in very pleasing manner, I have seen many cases where the counsels were able to fetch fantastic orders on behalf of their clients. It is very important. The art of advocacy is not that easy, my dear friends. One has to remember that. Alright, that is very important, what I told you about the art of advocacy and what is all about arguments. Arguments is not shouting like you see in the movies. Alright, if you do that thing, the file will be thrown at your face. Immediately you will be taken into custody. The advocates I'm talking about, you will go to jail. As simple as that. The advocates will be imprisoned. There are many instances where the advocates have been held for contempt for shouting on the courts. It has happened many times. I've seen in Telangana High Court, Delhi High Court. This is very common. The Supreme Court also. But sometimes Supreme Court, they'll go little slow, and they will accept the apology, and they will give the pardon. So that is a different thing, but one should not behave like that. All this has cropped up because of the topic of best advocates. Best advocates are the ones who are going to bend before the judge and get you an order. That is the best form of advocacy. That is the art of advocacy. So always hire an arguing counsel or an advocate who has got very good knowledge, and apart from knowledge, who has got good spoken English. That is very important. In constitutional courts, without English, there is nothing that one can do. That is second thing. And last but not the least, who speaks in a proper decorum, not the person who shouts at the court. If the advocate is shouting on the court, even if you take NOC, next time when you go with another counsel, the judge will keep it in mind and he'll dismiss your case. So always be very careful with such kind of advocates who are very aggressive and who shout on the courts. That is wrong form of advocacy. They will be in big time soup soon. So the best advocates in the Telangana High Court, the best advocates in the Delhi High Court, the best advocates in the Madras High Court, the best advocates in the Karnataka High Court, all these high courts, or the best advocates in the Supreme Court, are the ones who argue with the proper decorum. That is most important. Thank you, my dear friends.